Hello, everyone, and welcome to Uncivil Law, where we gain legal education through the misfortunes of others. As always, if you're enjoying our legal education content, please remember to hit the subscribe button and also hit the notification bell. For today's case, we're dealing with the CDC's eviction moratorium, this time from the Court of Appeals for the D.C. Circuit. We recently covered this exact same issue from the Fifth Circuit Court of Appeals, who, like other courts of appeals, have said that the CDC does not have the power to stop evictions in the name of coronavirus. They might be able to do a whole bunch of things for coronavirus. They might be able to quarantine people. They might be able to destroy property if it's infected. They might be able to take measures to sanitize, but not so much with the stopping people from being evicted. Unless you're the DC Court of Appeals, in which case you say, sure, that too. So since this goes exactly against the Fifth Circuit Court of Appeals, we're going to read this and try to figure out why the DC Court of Appeals came to a different decision. Why the CDC supposedly has this power to stop evictions everywhere. Let's get started with this. The United States Department of Health and Human Services, the Center for Disease Control, and other federal agencies and officials, collectively Health and Human Services, appeal the district court's order entering summary judgment in favor of appellees and vacating the national temporary eviction moratorium. So the district court, like many of the other courts of appeal, said, no, the CDC can't do this. And the HHS has appealed to the Court of Appeals and says, how about we can? Shortly after HHS noticed this appeal, which is the first step of bringing the appeal, the district court entered an administrative stay of its order, and HHS filed in court a contingent motion for a stay. So one of the things that you might want to know is whether or not the district court's decision is going to be in effect while the appeal is ongoing. And here the district court said, no, it's not going to be in effect while the appeal is ongoing, which, fair enough. The district court subsequently stayed its own judgment. The appellees have filed in this court an emergency motion to vacate. Upon considering the motion, the opposition thereto in reply, HHS motion for stay and motion to leave as an amicus briefing is hereby ordered as following. The motion to vacate the stay pending appeal be denied. So the stay that's barring this order from going into place is still in place. So the district court has said that HHS can't do this, and then they said, we're going to prevent our own order from going into effect. And the Court of Appeals said, you can't undo that. So the court reviews the district court's decision under an abuse of discretion. All right, so here's the analysis. The district court did not abuse its discretion in granting a stay in this case. Under the traditional four-factor test for a stay, which is another way of saying an injunction, so this should look real familiar, right? We ask whether the stay applicant has made a strong showing of likelihood of success, the applicant will be irreparably injured, the issuance of a stay would injure the other party, and public interest. So, will you win? How much does it hurt you? How much does it hurt the other guy? How much does it hurt everybody? While appellees object to district court's use of a sliding scale analysis, we do not and need not address the propriety of that approach because the appellees have not shown a vacator as warranted under likelihood of success that they'd apply. So the likelihood of success, the Court of Appeals says, is the most important factor, which, sure, it is. And they feel like that the one party has a really good chance of winning. Okay. As to the first factor, while of course not receiving ultimate merits of legal question, we conclude HHS has made a strong showing it's likely to succeed. So HHS has a high probability, not necessarily 50%, because we'd be done as far as civil cases are, right? So we're not 50%, but something more than just, mere possibility. So sufficiently good, whatever that is. Let's say 30%. Okay, first, the CDC's eviction moratorium falls within the plain text of the law. Well, okay. The Fifth Circuit Court of Appeals directly disagrees with you. The Fifth Circuit Court of Appeals thinks that it doesn't fall within the plain text of the law. And I read the plain text of the law, and I thought that the Fifth Circuit was probably correct. But the Court of Appeals for D.C. says, no, actually, I was wrong. And it is within the plain text the whole time. I'm sure at any point they're going to cite to me where it's in the plain text so that we can all realize our collective error, right? Okay. Congress expressly determined that responding to events that by their very nature are unpredictable, exigent, and pose grave danger to human life and health requires prompt and calibrated actions grounded in expert public health judgments. Okay. Section 264 authorizes the Secretary of Health and Human Services to make and enforce such regulation as in his judgment are necessary to prevent the introduction, transmission, or spread of communicable diseases from foreign countries in the states or possessions, or from one state or possession into any other state or possession. Which an eviction moratorium is in the plain text there? I don't know, man. Congress thereby designates HHS's secretary the expert best positioned to determine the need for such preventative measures, twice stating it authorizes such measures as the secretary determines in his judgment are necessary. Right, so the Health and Human Services secretary is the person who has the authority to make this decision and whose judgment is the one that's going to implement this decision. But that doesn't necessarily mean that their judgment expands to all possible domains, right? It's the judgment within their domain. So they have judgment within their domain, whatever that is. If I hire you, just as a really trivial example, if I hire you to help run a count the number of M&Ms in the container contest at a local fair, you have judgment to operate that within those domains. So, presuming I didn't give you any other instructions, you might be able to choose the number of containers or how full to make the container with the M&Ms or even what kind of M&Ms to use, because peanut M&Ms certainly aren't the same size as regular, or maybe you can make a mix, make it even more fun, right? So they're not all uniform, make it more challenging, right? So you have judgment, and your judgment is within that domain. But just because you have judgment to run the how many M&Ms in the container contest doesn't necessarily mean you get to control the rest of the fair or the rest of reality. Your judgment, as extensive as it is limited within your charge. So Health and Human Services over here, sure, they have the ability to have regulations relating to health, especially as it relates to the transmission of diseases between countries or between states. I'm not sure how on a plain text issue we're getting to stopping evictions, though. Okay. The text also makes the determination of necessity a prerequisite to any exercise of authority. And that necessity standard constrains the grant of authority in a material and substantial way. Okay. Here to ensure the moratorium was tailored to the necessity that prompted it, Health and Human Services carefully targeted it to a subset of evictions it deemed to be necessary to curb the spread of a deadly and quickly spreading pandemic. How does stopping evictions help towards that goal? Among other problems, especially as it relates to between the U.S. and other countries or between states. If you're evicted, you're more likely to move. Notably, appellees do not dispute HHS's determination the moratorium would prevent interstate introduction, transmission, or spread. Well, they might, but I'm a little bit dubious. They might not dispute that, but I'm going to at least raise the question. Maybe it does, maybe it doesn't, but it's not immediately obvious. If a person is evicted, they're more likely to move between states or something, or I don't know. The agency reasonably recognized that evicted people must move and that time-limited eviction moratorium would directly promote the self-isolation needed to control the pandemic. The moratorium also applies only to those renters the agency determined otherwise would likely need to move to congregate settings where COVID spreads quickly and easily, or be rendered homeless and forced into shelters or other settings. How do they limit it that way? How do the regulations limit it that way? How do they determine those people from other people who are renting? In those ways, the moratorium fits within the textual authority to adopt measures necessary to prevent the spread of the pandemic. By going into an area of intra-state regulation. Because lots of things might be interstate commerce, but the regulation of rent is an intrastate issue. States regulate rent. They're the ones that, control landlord-tenant law and all that great stuff, which it's a matter of state province. And you would imagine if Congress was going to abrogate that in some way, they'd be a little bit clearer than, yeah, you can do things to prevent disease spread. To the extent that people being evicted would be a transmitter of interstate disease, this is not exactly a COVID-related problem as opposed to disease-related problem. So it's not that Congress couldn't see that coming. I wouldn't know for sure, but I would imagine that whatever would be true now with respect to people being evicted and moving would have been true in the past with respect to other diseases. And this is this is going to an area of state regulation. So we're reading a lot into this that's not readily apparent. Second, Congress has expressly recognized that an agency has authority to issue narrowly crafted. Last December, rather than enact its own moratorium, Congress deliberately chose legislatively to extend HHS's moratorium, and doing so specifically to embrace the action. Yeah, the Fifth Circuit looks at this differently, and I'm inclined to look at this the way the Fifth Circuit does, right? Congress can ratify, which is the technical word for this, right? Ratify is exactly the right word you want in the sentence, by the way. Congress can ratify an action that was improper at the time. So Congress can say, okay, you didn't have the ability to do this, but I'm going to now give you my imprimatur, my authority, and say, okay, it was okay. I'm going to adopt it. It would be the equivalent, although the analogy isn't perfect, so bear with me. But if you hired someone to do a particular task, so they're your agent, and they did something that's outside their authority, right? You might be able to say, you know what, even though I didn't give you that authority, I'm going to adopt voluntarily that responsibility. As it turns out, I am pleased that you took that action, even though it wasn't within your charge. So I'm going to ratify that and basically retroactively say that was okay. Now, that isn't the same thing as retroactively giving you the power. And it's certainly not the same thing as saying you have the power in the past. But it is the power to say this thing that was outside the domain. I am, for this purpose, this time, going to say it's okay. And Congress said, we're going to extend it. And they extended it for a period. That's what the Fifth Circuit said. It was ratification, not modification of the power. That seems basically right. But the D.C. Court of Appeals apparently reads this as, because you adopted the action, you were acquiescing to the underlying claim of power, which isn't quite correct. Third, the text of the structure of the statutes, additional provisions, beyond core statutory authority to take necessary action to prevent the induction, transmission, or spread of communicable diseases, interstate and internationally, but please note not intrastate, where landlord-tenant law is definitely more dominant, reinforces HHS's authority to temporarily suspend evictions. The second sentence of Section 264A provides that, for the purpose of carrying out and enforcing such regulations as are authorized from the provision's first sentence, The Surgeon General may provide for such inspection, fumigation, disinfection, sanitation, pest extermination, destruction of animals, or articles. Right? We remember this language from before. So, in order to carry out those regulations, the Surgeon General can provide for these specific things and other stuff. We've discussed how to deal with and other stuff before, right? When you have a general provision like and other stuff, it is informed and limited by the specific stuff that it surrounds. If I say, again, going back to my carnival example, if I say you have the authority to buy the containers, to buy the M&Ms, and other things that will help you run the game. The other things are like the containers and the M&Ms. They are part. I have basically given you two species of a class, or two species of a genus, if we want to go that way, right? I have given you two specific species of a genus that I'm not going to make very clear, but I'm giving you species and saying, okay, these species belong to a genus or a class, and you can do things that are in the class or genus. And if you now suddenly go do other things, you're not within the and other stuff. You're not within the same class. Doesn't mean all other stuff. So the court continues. That language makes clear, does it though, that HHS has even the exceptional authority to take measures its regulations that Congress in 1944 had reason to believe required express constitutional authorization under the Fourth Amendment. Okay. So I concede the premise, but the conclusion doesn't follow. So the language does make clear that HHS does have exceptional authority. I very much agree with you. In fact, perhaps too much so do I agree with you, that it is exceptional. This is not the rule. This is the exception. The rule would be state regulation. The rule would be state control. That's how we work in a federalist system, right? So this is very much exceptional. So Congress, believing that it was exceptional and believing it required express authorization, gave express authorization. And the express authorization that was exceptional was for the express inspection, fumigation, disinfection, sanitation, pest extermination, destruction of animals or articles, and other stuff. So, not so much with the eviction moratorium, I think. Appellees argue the balance of 264 constricts the scope of the regulatory authority, and the moratorium exceeds that authority. That seems like the better argument to me. They argue, in particular, the regulatory power under the first sentence of Section 264 is limited in measures closely akin to those of the second sentence enumerations. That is incorrect. Really? By its plain wording, the second sentence applies not to the substantive scope of the authority, but to measures that HHS can deploy to carry out and enforce the regulations. Okay, so you want to say that in this first sentence, Congress is saying, here's your power to do stuff. And in your second sentence, here's your power to enforce the stuff. Right? So you have limited power to enforce, but not maybe more limited power to enact. So your enforcement mechanisms are more restrained. Well, even if that's true, I don't know necessarily sure how it follows, because the enforcement mechanisms don't include stopping evictions. Also, the power being to enforce is suggestive of the scope of the regulations in the first place. This is a language of expansion, not contraction, designed to strengthen HHS's ability to take the measures necessary. The insurance, then why, if the that doesn't really make sense. If HHS has the power to make any and all regulations necessary to make the health, then how does the language expand? How it can't expand because the language, according to your reading, is already as expansive as it could be. It would be at best descriptive, not expansive. If it's expansive, that kind of reads against because it suggests that it wasn't there and we had to add to it. So your own logic sort of defeats your position on that one. Indeed, contrary to the cramped reading of 264, appellees acknowledge in their reply brief that 264's regulatory power includes the power to prevent interstate movement of contagious persons. Yes, in a different section relating to quarantines. For that matter, it regulates their ability to do intrastate movement, or really any movement of any variety. That would be the nature of a quarantine. But that is the objective of the eviction moratorium. It might be the objective, but it's not the same thing. HHS is likely to succeed notwithstanding appellees' other statutory construction arguments. Appellees suggest that a moratorium reaching rental property should be narrowly construed to avoid intrusion on an area left to the states. That's a very good suggestion. That's a very good suggestion, appellees. That is a very good suggestion. We work in a federalist system. According to the Ninth Amendment and the 10th Amendment that we all know and love, right? The states have power, and that the federal government has some other power, maybe sometimes, right? The states have all the residual power, and this is definitely, typically, a state-level inquiry. Rental or ownership of property, for that matter, is pretty state-focused. Not a whole lot of federal law going on that one. So, all else being equal, we should avoid reading a regulation in a way that's going to so directly, because I'm not sure what the total scope or the total list of what are the most core state level powers are, but regulation of property's got to be up there somewhere, because it's got to be pretty core to the state interest in terms of each individual state, in terms of its property. So in terms of state interest, yeah. So if Congress is going to modify that, presumably be a little bit more direct. Okay. Congress has a well-established authority to regulate rental housing transactions because they substantially affect interstate commerce. Yes, they can. But the question is, did they? Tellingly, under appellee's Commerce Clause theory, even congressional extension moratorium was unconstitutional. No, that's not correct. And that's not even what they're saying now. They're not saying it's unconstitutional. Or at least that's not what you just said they said. They said it should be narrowly construed to avoid this result. That is not the same thing as saying it's unconstitutional. It's simply saying that you should try to avoid that. Now, it's not saying that if it says it is constitutional or not. It's not taking a position on it one way or another. So your conclusion here does not follow the premise that you said. You said the appellees say, hey, how about construe this power narrowly? Or construe the language narrowly, and you said, wow, geez, that means it's unconstitutional. No, it's just not necessarily what Congress did. What Congress can do and what Congress did do are not necessarily the same thing. HHS also is likely to succeed despite the federalism objections, which I've been talking about for a little bit now, because Congress expressly empowered HHS to act in areas of traditional state authority when necessary to prevent interstate transmission of disease. Sure, I accept your premise because regulation of health is also a classically state-level concern. And I also concede the point that the federal law has, to some degree, overtaken this traditional state authority. It did it so kind of expressly in the express language we've been talking about. So sure, yeah, this is an area of traditional state domain, and Congress wrote some laws that made at least some aspects of that traditionally state domain at least concurrent federal interest, if not dominant federal interest. But that doesn't imply that they overtook the entire field. Appellee's major question objection does not change the calculus. Given the statute's plain text, they keep saying plain text, I'm not sure it means what you think it means, and Congress's explicit embrace. As for Appellee's non-delegation argument, 264's requirement that the regulatory measures adopted be necessary to prevent the induction, transmission, or spread of disease provides an intelligible principle. I agree with that much, actually. The non-delegation thing isn't going to work. So I concede your point on that one. Yeah, you win the HHS, you win the delegation argument. It's just that I don't think Congress delegated it to you. So for me, it's not they can't delegate it to you so much as they didn't delegate it to you. What Congress can do and what they did do are two distinctly things that I think I mentioned. To be sure, HHS has not previously imposed a rental eviction moratorium, which, given the age of this law and given diseases that we've seen in the past, might be suggestive. But no public health crisis even approaching the scale and gravity of this one has occurred since the act was passed in 1944. I'm sure some people in the comments might disagree. Appellees point to the lack of other eviction moratorium as a reason to question the power. But the paucity of examples more likely underscores the statutory constraints on the authoritative work. The district court acted within its discretion in concluding that the remaining factors supported its stay of its own order. Well, I don't know about that. I mean, the district court is recognizing that it's taking action against an agency, and I don't necessarily blame the district court for its issuing the stay. It makes logical sense while the thing is being appealed. But the Court of Appeals rationale is leaving a lot less to be desired. So, yeah. HHS has demonstrated that lifting the national moratorium will exacerbate the significant public health risks identified by the CDC because even with increasing vaccinations, COVID-19 continues to spread. The governor's interest in avoiding this harm merges with public interest. Well, that's always true, definitionally. And when the government is the party, it always merges. So that last line is kind of a truism. So that doesn't really mean anything here. As for harm to other parties, including appellees, the record does not demonstrate any likelihood of irreparable injury. Really? There's no likelihood of irreparable injury to all these rental moratoriums? Okay. I mean, I was under the impression that property rights were considered to some degree irreparable. Appellee's brief makes conclusory references to general financial harms that could befall landlords nationwide, also the infringement of the property. But the record is devoid of the requisite evidence of irreparable injury. In particular, the record does not demonstrate any likelihood that appellees themselves will lose their businesses. Really? From not getting paid? That an acceptable percentage of their own tenants who will otherwise pay will be unable to pay, or that financial shortfalls are unlikely to be mitigated. To the contrary, the calibrated design of the moratorium evinces and embodies the statutory limitations, ensuring that these are all necessary. Again, not sure that word necessarily means what you think it means. More specifically, the moratorium imposes several exacting. Really? Exacting? Conditions that circumscribe the reach and degree of relief the order provides. For starters, not all tenants qualify. The moratorium applies only to renters who cannot find other non-shared, non-congregate housing, which, presumably they only have to say they do, and whose economic needs meets a stated level, because if they're rich, then they can't spread the disease, arises from specified circumstances and cannot be abated. And the order allows landlords to initiate eviction proceedings and even to obtain removal orders. It's just that, you can't do anything with them. So sure, get your eviction proceedings going. Get your eviction order. Just, they're worth the paper they're printed on. On top of that, the obligation to pay all rent is due remains. That's true. Hope you can collect that, but yes. And the provision has been made to address interim shortfalls. Even those tenants who do qualify for protection remain obligated to pay their rent, which I'm sure will happen, and to make best efforts to pay. The other order specifically preserves landlords' legal rights to recover all rents owed with interest and penalties. So I guess the idea is that they can be made full with money. Okay. I might have to give the Court of Appeals this one, even though I'm not particularly happy about it, but I always try to be honest when I'm evaluating these things. Can the landlords be made right with money? Well, we always assume that money will be sufficient, but I still think the likelihood of success is nowhere. So yeah, we can fix it, but it's not really working for me. So they might be right here, but the likelihood of success is off. In the meantime, Congress has allocated substantial sums of money for rental assistance. Okay, the fact that appellees waited 11 weeks to bring their challenge and have not asked their court for expedited resolution suggests the moratorium does not impose irreparable harm. Given all that, the district court properly concluded the appellee's financial loss are at least partially recoverable. Well, that's not the standard. Partially recoverable. It's supposed to be recoverable. So is there irreparable harm or not? If it's partially recoverable, that might mean it's in part not recoverable, which might mean that in part it's irreparable and partially mitigated. How about the rest of the mitigation? Through relief from Congress, and the magnitude of the loss is heavily outweighed by the interest in protecting the health. For the foregoing reasons, the district court did not abuse its discretion. Well, if you say so, let's go back to the top. Thus, that leads us to the end of the case of Alabama Association of Realtors versus United States Department of Health. In this case, a group of renters, a group of landlords, sue, saying we're not getting money and it's our property and you can't do this. And the court says you can be paid back, which they seem to disagree with themselves on that, because they say you can be repaired and then say things like partially, which suggests maybe not so much with the reparable harm. Maybe some of it's irreparable, but we're going to ignore that. And we're also going to ignore that this doesn't make sense because Congress has the power maybe to do this, but you're going to say they did do it in plain text clearly. I mean, I don't really think so. And then you mischaracterize the arguments by saying the opposition, the landlords say you should avoid reading it this way. And you say, well, that would make it unconstitutional, which is not at all what they said. But yeah, so this is in direct conflict with several other courts of appeal decision, including the Fifth Circuit. So will the U.S. Supreme Court take this? If I were a betting man, probably not, but who knows? But until next time, we'll see. Thank you so much for being part of the Uncivil Law family. If you enjoyed this legal education content, please hit the subscribe button. It really helps the channel grow. We appreciate your continuing support. And until later, my friends, cheers and goodbye.